is Casey Ashmore coming to you from the studio. Thank you again for watching. Please like, subscribe, and share. Questions or comments, chat at ashmorelawfirm.com. Chat at ashmorelawfirm.com. So I'm talking in this video series about Texas family law cases, and this is a kind of a deep dive into how you can avoid costs or increase costs, right? Cost, length of lawsuit, overtime equals more attorney's fees. So one of the things that we talked about in the prior video segment is that at the beginning of a Texas family law case, once both parties are served, something comes into effect. It is called the 60-day cooling off period. 60 days is a long time, but it's really not a long time. It's 2 short calendar months, right? And it can go quick. And you really can't do a whole lot in that 60-day period except exchange information requests, the discovery, right? That's written questions to each side about assets, debts, who's a better parent, things like that, what happened during the marriage. But it has to be related to parenting rights and property division. So the other thing that you can ask the court to do, and it's still part of our Texas family codes, you can ask the court to order the parties to go to counseling. And now that's a rare thing to occur. It does happen from time to time. And sometimes it can save a marriage. Sometimes it can save a marriage. But if that's a request you're making with the hope that prolonging the divorce will give some chance at reconciliation, that may be a slim hope or a false hope. And again, the more time you're in litigation, the more chance you have of increasing your costs. And that can be, especially if the other party is very resistant to the notion of extending the proceeding, right? If they're resisting the notion of, I'm not going to counseling with you, it's not me, it's you. You need to go work on you. I'm not going to counseling on anything. I'm fine. And that doesn't advance the ball down the field. That doesn't move the needle, because all it does is prolong the case over time and increases the probability that the resources you'll have to invest in the case will continue to go up. So prolonging the divorce, giving a chance for reconciliation. Sometimes it works, and sometimes asking the court for that rarely used statute to say order the parties to the maximum amount of counseling possible. Sometimes that can help, but that's a big, big ask, and the courts don't always give it. In fact, they're reluctant to give it because they don't want to be the boss of you, right? You know, you want to go to counseling, go to counseling. You want your spouse to go to counseling, convince your spouse to go to counseling. Don't tell the court that you need to order the spouses to go to counseling, because if they're not going voluntarily, they're not going to buy into it. And I'm not saying every court's going to see it that way, but many do. They don't want to be your parent. They want you two to parent. So they want the spouses to parent. Anyway, it's a big, big issue, and it's a thorny one for any court to deal with. But it is there, and that is some relief, but it's also one that may not help. You know, all you'll end up doing, more likely than not, or you're taking that risk, is that you're going to increase your costs because you're going to continue to invest in that case over time. So anyway, any questions or comments, chat at ashmorelawfirm.com. Chat at ashmorelawfirm.com. More to come on family law next in the studio. Thank you.